My name is Michael Tunnicliffe. I'm an associate solicitor here at Sills Betteridge within our claims department. I represent individuals who have been involved in accidents and unfortunately suffered personal injury and other losses as a result of those accidents. Unfortunately, personal injury claims are quite complicated and there are often misconceptions and myths surrounding personal injury claims. The purpose of this video is to try and explain and discuss some of those myths and misconceptions, and it gives me opportunity to discuss how personal injury claims work and what things you should be looking out for moving forwards. So many people think they would benefit by going directly to a defendant insurance company, and often, or at least sometimes, the process can be quicker. But I don't think, and we don't think, your interests are best served by going through a defending company directly, as it's in their interest to try and diminish the value of your claim. It's in their interest and in their business model to try and limit what compensation they pay out to you. By instructing an independent law firm, it does mean that your interests are protected and they will look to try and get the most compensation that you deserve. So here at Sills Betteridge, we work under no-win, no-fee agreements, also known as conditional fee agreements. The benefit of a no-win, no-fee agreement is that the work that's incurred to pursue your personal injury claim is written off should your claim fail. It means that you can pursue a personal injury claim without that financial risk of paying for your legal fees should you lose. Often people are unaware that they have legal expenses insurance which will allow them to pursue personal injury claims within their motor insurance or their home insurance. Now, those insurance policies, those legal expenses insurance policies, which require you to use one of their panel firms, we would suggest aren't in your best interests. Unfortunately, when using panel firms, they are most often not local to you, and we think your interests are best served by using a local firm. The benefit is that you get to meet with us, it's more efficient, and you know exactly who is running your claim. Unfortunately, every personal injury claim is different, and there are a variety of factors which can have an impact as to how long the personal injury claim may take. The biggest one that we encounter is medical evidence. So we would never recommend that you look to settle your claim before you recover from your injuries, or at least until you receive a final prognosis. This is because personal injury claims are in final settlement, which means that you are not able to recover compensation later on down the line should your injury be more serious than it turns out to be. So it's always in your interest to, unfortunately, sometimes have that delay with personal injury claims to make sure you get the full compensation that you deserve. One of the things to try and help alleviate some of the difficulties caused by delays in personal injury claims is what's known as interim payments. Interim payments are a part payment of your damages which are received prior to the completion of your claim. The purpose of an interim payment is to help fund immediate losses that you may have experienced while suffering from your accident, or to help with your recovery. It can fund treatment costs. Unfortunately, sometimes court proceedings cannot be avoided. It may be the case that a defendant's insurer or a defendant themselves are refusing to offer a settlement which we think you're deserving of. In those circumstances, we, acting as your solicitors or a barrister, will handle those proceedings on your behalf. If you have an accident at work, you will still have to prove that the defendant has caused some sort of negligence. This can be via failure to provide PPE, failure to provide instruction, or failure to provide training. It isn't the case that you can simply make a personal injury claim against your employer's insurance without first proving some form of negligence. There is generally a 3-year time limit in order to pursue personal injury claims. This is either 3 years from the date of the accident or 3 years from the date of your awareness of the injury. There are some exceptions to this, so for example for children, where it's 3 years from the date of they turn 18, and there's also exceptions, for example, where someone has lost mental capacity. I would always recommend that you look to instruct solicitors or legal representation sooner rather than later, as personal injury claims are often harder to prove the longer you go from the date of the accident without first obtaining the evidence that you need to. Personal injury claims are often more complicated than people realise, but they don't have to be intimidating. By understanding the realities behind the myths, you can confidently navigate the claims process.